Okay, good evening. Gonna get going. Appreciate everyone coming on yet another Tuesday night meeting. I think we're on a track record to break a record here. So good job, select board and town administration team. In accordance with chapter 2 of the Acts of 2023, tonight's February 25th, 2025. Public meeting of the select board shall be conducted remotely via Zoom. The agenda is posted on the town's website and it identifies how the public may join. Please note that this meeting is being recorded. We ask that everyone remains on mute as this is, there's a lot of people on the call. We expect there to be a bunch of people on the call. As a preliminary matter, this is Select Board Vice Chair Chris Gallo. Please permit me to confirm that all members and persons anticipated on the agenda are present and can hear me. Members, when I call your name, please respond in the affirmative. Selectman Jim Anderson.
Anderson here.
All right, so Jimmy's, just so the board knows, Jimmy's calling in from his cell phone. He's doing us a big favor being here. So that's him. Thanks, Jim. Bill Harrington.
Harrington here.
Selectwoman Rouse.
Rouse here.
Staff, when I call your name, please respond in the affirmative. Interim Town Manager Mike King.
Present.
Assistant Town Manager Greg Enos.
Present.
Executive Assistant Amanda Vazzapolo.
Present.
Okay, meeting is now in order, in session. So, Bill, we have no announcements tonight, so you're off the hook. We have really one item to discuss this evening. And it is that is the discussion of the state auditor's determination that the MBTA Communities Act constitutes an unfunded mandate. And we're here to discuss next steps. We have with us Town Council Jay Tellerman. Jay, thank you for joining us this evening. And before we turn it over to you, I thought we would just kind of give a quick recap to the viewing audience, anyone that might be listening, to know kind of how we got to this point. I'll take a first stab at it, and then I'll ask interim Mike King to fill in any gaps, as I'm sure there might be a few. But, you know, we're here tonight because we've been discussing the MBTA zoning mandate for a while now. We've had countless meetings. We've done, you know, we had a town meeting just recently where the town, you know, very emphatically voted no, 553 to 53 or whatever it was. I think those are pretty accurate numbers. And the reason that the townspeople voted no, there were three major reasons. We wanted to wait and see, number one, what the outcome of the Milton case is. We now have that, and we're going to discuss that tonight. Reason number two, we wanted to get the state's determination whether this is or is not in fact an unfunded mandate. When we solicited that from the state auditor, we now have that. And the third piece that we still do not have is the fiscal impact analysis. Those are the three things that this board emphatically, you know, spoke about with the townspeople at town meeting, why the MBTA Communities Act was voted down. So now we have two of the three things. The biggest one, well, the most recent one is this determination of unfunded mandate. So I'm going to turn it over to Mike King before turning it over to Attorney Tellerman to discuss what does this mean for us, the Wrentham voting taxpayer residents, and what the next steps might be. So at this time, Mike King, do you mind giving a quick summary of filling in anything I might have forgotten, and then we could turn it over to Jay.
Thank you, Mr. Vice Chair. So yes, I will provide an overview of the unfunded mandate request timeline. Essentially, how did we get here? So
Looks like a MAGA guy.
back in October,
Mike, hold on one second. I'm going to ask everyone again, please mute your phones except for Jim Anderson. And Amanda, if you see that anyone's on muting, do you mind muting? We got to keep this tight so we can keep it moving. Go ahead, Mike.
All right, thank you. So on October 15th, 2024, per Mass General Law, Chapter 29, Section 27C, known as the Local Mandate Law, the Wrentham Select Board exercised its right to request that the State Auditor's Division of Local Mandates determine whether fiscal impacts related to the MBTA Communities Act represent a potential unfunded state mandate. The select board further requested at the time that the division determine the total annual financial impact of the act for a period of no less than 3 years, as provided for in the local mandate statute. The requests were made timely in October so that the division would be statutorily required to provide its determinations prior to the December 16th town meeting, as state statute mandates that a determination must be made within 60 days of a request. However, the Division of Local Mandates declined to offer a determination at that time due to pending MBTA communities litigation between the Attorney General and the town of Milton that was then before the Supreme Judicial Court of Massachusetts. The Division of Local Mandates did ask for a waiver of the 60-day timeline requirement, which the Select Board declined to extend in order to provide what would have been critical information for voters at the December 16th town meeting. The Supreme Judicial Court later did issue a decision in the Milton case on January 8th, 2025, which found that the MBTA community statute itself is constitutional, but that the state did not follow the proper procedure in promulgating the guidelines. The State Auditor's Division of Local Mandates has since reviewed the Milton decision, and this past Friday, February 21st, issued its determination, as requested by the Select Board, that the MBTA Communities Act does constitute an unfunded mandate. The State Auditor's Office, in its determination, referenced the Supreme Judicial Court ruling in the Milton case that the act is a mandate and that the state's existing funding mechanisms for compliance costs incurred by municipalities do not fulfill the requirements of the local mandate law. Municipalities such as Wrentham can either comply with the act with no guarantee of reimbursement for expenses incurred, or, under the local mandate law, petition the Superior Court for an exemption from compliance until funding is provided. I will importantly note, as the Vice Chair made mention, that the town of Wrentham is still awaiting the issuance of its requested fiscal impact analysis from the State Auditor's Division of Local Mandates, which will determine the financial costs of complying with the MBTA Communities Act. This concludes my quick overview of the unfunded mandate timeline, and I believe Attorney Tallerman will further discuss the State Auditor's determination and review possible next steps.
Yes, thank you, Mike. Appreciate the summary. Jay, we're going to, Attorney Tallerman, we're going to turn it over to you. I would ask you to obviously give us an overview in your opinion. What does this mean for Wrentham? I would ask you to touch on things that Mike mentioned, the Milton case, the effects of the Milton case, if any, and, what our options are, Attorney Tallerman, moving forward. So at this time, thank you for being with us tonight, and the floor is yours.
Great, thank you. And Jay is fine, Chris. So I think it's helpful, as Mike touched on a little bit, for us to go backwards a little bit before we talk about where we are now and where we may be tomorrow, next week, next month. So the MBTA zoning statute is remarkable, not just for what it requires, which it requires that towns undertake zoning that would require by right zoning of multifamily housing. It's also remarkable because it, unlike other zoning initiatives, including zoning initiatives under Chapter 40B, perhaps, or under the Dover Amendment, there are penalties within the statute for failure to comply. Those penalties are limited in the language of the statute to just the loss of potential grant funding over a number of different categories, and perhaps a few more grants than that. So the way the statute is set up is it appears on face value that the worst a town could do, and this was at issue in the Milton case, was lose grant money. Now, that could be a bad outcome in many instances, but it also allows a town to make a choice as to whether or not it wants to do the zoning or do the grants. There are a few issues at play in the Milton case. One of them was a challenge by Milton as to whether or not the statute itself was legal and constitutional. we always felt that that was somewhat of a foregone conclusion, that on its face, it's probably legal. There's a number of different statutes that require towns to do something in and around zoning. So we felt that that probably wouldn't go Milton's way. But another thing that I think is important in that case is the state wasn't just merely seeking to validate their statute and everything about it that is written within it. They wanted to have the court determine that, notwithstanding the penalty provisions in there, there was still an inherent obligation, not a choice, a mandatory obligation. And the term mandatory is really important as this plays out. And they fought for that. And that was a key component of their arguments before the Supreme Judicial Court. Ultimately, after a testy back and forth and a long time with the Supreme Judicial Court hearing this, the Supreme Judicial Court did a few things. It validated the constitutionality of the statute. However, it did throw out all of the guidelines because it felt that that could only be done by rulemaking. So it wasn't a complete loss for municipalities, because we got an opportunity then to participate in the public process in and around the adoption of regulations. From the state's perspective, the most important victory that they have, if you can call it that, and we'll get into the reasons for that in a moment, was that it said, in addition to the penalty provisions, loss of grant funds, every town has to adopt this. It is absolutely mandatory that you have to do this. It left unstated, however, how the state may compel that. And I think that's a story that is still out there to be written for the towns that truly choose not to do it at the end of the day, which could be this July, it could be a few years from now or whenever. But that is a story that hasn't been written. So the issues under Milton are not fully resolved yet. Okay, but let's flash forward here. As Mike said, the town exercised its rights along with a few other towns who were in a relatively similar boat, and to petition the state auditor, Division of Local Mandates, for a determination as to whether or not this constituted an unfunded mandate. An unfunded mandate's it's mostly what you think it is, but it can get a little technical. To kind of distill it down to its essence, the unfunded mandate statute requires that at the time a statute is drafted, at the time the statute is drafted and put into play, if there is going to be a cost to a municipality, and it has to be like a real cost, not an administrative cost, but a cost on infrastructure or the means of you doing business, the state is required since 1980 to fund that cost. If you don't fund it, it's deemed an unfunded mandate. We throw that term around with state, with local, with federal taxes all the time, but it has a very specific definition under the statutes implemented and regulated by the state's auditor and the Division of Local Mandates, which is part of the state auditor's office. So when we petition, when a town suggests, and it's not in just this format, but with any statute, that a statute that was passed, either a special or a general law, the argument is that it's not about reimbursing you. It's about, did you give us the tools at the beginning? Did you tell us what we were going to get to then implement and comply with the statute? Because the state is not allowed to make mandates of a town unless they are funding them. Now, towns have argued for a lot of years that there are various unfunded mandates. And there's been a number of suits over the years where towns have challenged in court whether or not particular statutes, whether they're general laws adopted by the legislature or special acts, constitute an unfunded mandate. It is very infrequent when those suits are based upon an actual finding of the auditor. Usually it's a town that is very upset with or disappointed or confused by a statute where they challenge it to try and make sure that there's it's either could be invalidated or they don't have to comply with it because there's no funding. Towns have not fared too well with that because they're left on their own to fight the state government on whether or not it's an unfunded mandate. Generally, not always, but generally towns have not succeeded in those efforts. This is a remarkably different fact pattern because this town and other towns similarly situated, a few others, took it upon themselves to do what the statute allows it to do and seek a determination from the state's authority on this, the auditor's division of local mandates. And this auditor said, yes, it is an unfunded mandate. They reserved how much it is unfunded, but they drew a conclusion. Again, in none of the other cases that we've researched that amount to like binding precedent has that fact pattern. So there is a determination by the actual agency itself that is charged with determining whether or not something is unfunded, saying that yes, it is. They don't know how much, and they said it is the job of the state, not the town of Wrentham, not the other towns, to fund it. And that obligation is retroactive to the date that the statute was passed. So it's not that the town has to determine and make a calculation. It is now up to the state, based upon the determination of the auditor, to do that. But the statute says something different, or in addition to that, it says that if you are essentially shackled with a statute that constitutes an unfunded mandate, then you are able to petition the Superior Court. And again, the reason we're here that it's an unfunded mandate is because the state wanted this statute to be a mandate, and they won. They won that case, and now it's an unfunded mandate. If the Milton court had gone a different way and said it's not a mandate at all, you have a choice, there's penalties, but you have a choice, then we wouldn't be where we are. So that's why it took some time, but here we are. So now what do we do as a community with the information available to us, which is a determination by a state agency? That state agency is entitled to deference, meaning it's presumed that their determinations are done carefully and in accordance with law, because that's what government entities do. No different than the Zoning Board of Appeals in Wrentham that might be entitled to deference when they say yes or no to a particular project. So the state is entitled to that. What do we do with that information now? We know, as an entity that hasn't complied with that statute yet, that there's a provision of that statute as reflected in the actual letter from the auditor saying that you have the right to petition to forestall compliance or to wait or defer or delay compliance with this statute until such time as it's funded. Now, it is important to note that none of what we're going to talk about constitutes a potential challenge to the legality of the underlying statute, the MBTA zoning. That issue was resolved in Milton. We're not arguing, nor could we, after the Milton case, the highest court in Massachusetts determined it. We can't argue that it's an illegal statute. We can argue, however, that we don't have to comply with it yet. That is an argument that the towns that have yet to comply, that would be both towns that chose not to, by the deadline, implement the statute, or the towns that still have an opportunity to do so, what we call the small adjacent communities, and there's several more of those out there. So how does that come about? How do we then utilize this statute or contemplate utilizing this statute in a way that carries out what the auditor said and what the auditor extended to us as a consequence of the legislature and EOHLC, which is the state agency implementing this law? What is the consequence of their failure, either purposely or unintentionally funding this particular statute. There's a number of different ways this comes up. But I want to state that it's really important to note that this is not a situation where I, as counsel, would say, boy, we've got a really difficult case out there because we've got to build a whole case as to why it's unfunded. This is a situation where the state already did that for us. That puts the town and other similarly situated towns in an incredible position of strength when it comes to determining your own destiny here. There's a whole spectrum of choices that the select board could take here. We can discuss them generally tonight, and then if we have an executive session at some other time, we can discuss them specifically and the relative benefits of each particular thing. So the first one on the one end of the spectrum is we could do nothing. The state auditor has already said that it's an unfunded mandate. We don't have to do anything. The deadline could come and go. And then if the state chose to enforce before they funded the mandate, then we could act defensively in that. That is one option that's out there. Option two, kind of moving up the spectrum a little bit, is we could choose to kind of wait and see how this unfolds. Obviously, based upon the statements of the Attorney General, there is significant consternation in that office as to this turn of events. I don't blame them per se. They thought that they were in a certain position, and now their position is much different. We don't know how they're going to fully react with this. I have had conversations with representatives of the Attorney General's office. They're still mulling the same way we're mulling as to what the next steps here would be. Could they challenge the auditor? Could they file their own action? Will they defend some other town's action? And might we get to see what that looks like as time goes on and bide our time and figure out what we want to do? We have a deadline ostensibly of July to comply with the statute, so there's some time to figure that out. We could also affirmatively now, and kind of the other end of the spectrum, sometime in the near future, file our own action in Superior Court. Superior courts are what we call courts of equity, where we can get an injunction. We're not getting an injunction. Again, if we sought an injunction, it wouldn't be for the purposes of stopping the statute dead in its tracks or having it be ruled invalid. Rather, as the auditor has already said in their letter, the purpose of seeking an injunction against the Commonwealth would be to just preserve the status quo where it is right now, excuse us from compliance until such time as we know what that fiscal impact analysis says and what the degree of funding is required to fund this particular mandate. That would be our ask of the court. We're not fighting old fights. We're not opening old wounds. We're trying to preserve our rights as a community, as fully illustrated in the auditor's letter, to do exactly what the state law allows us to do, nothing more, nothing less. Now, when you go and seek an injunction in court, there's a couple of different things that are important for the court to consider. The first thing that a court will always consider is, do you have a good case? They're not going to give you an injunction at the start of a case unless the court feels you have a reasonable likelihood of success on the merits. The second component is that the court has to balance the harms between what happens to you if they don't get an injunction and what would happen to the state if we did get an injunction. On the first issue, as I've already said, this is a situation where the state has already breathed life into the merits of our case. We're not trying to invent the wheel and make a strong argument as to why this may be an unfunded mandate. We've always felt as a community that it was, otherwise we wouldn't have written to the Division of Local Mandates in the first place. This is a situation where the Division of Local Mandates has determined in an official capacity that it is an unfunded mandate. So if I'm a Superior Court judge and a town comes to me and says, hey, I think we have a pretty good chance of success here, and we have a good chance of success because the state agency that's charged with doing this says we're right, says it's an unfunded mandate. So we cross that. Now, we don't know yet as to how the state might say there's not a reasonable chance of success on the merits. There's a few potential arguments they make. Mostly what we've heard from them so far, and I don't mean this in a pejorative sense, is that they just think the auditor was wrong. At the time of hearing and arguing before a court on a preliminary injunction, they're going to have to do better than that. And maybe they will have a good argument, but right now, the strongest argument is our argument because we can rely on the state agency that's charged with this. I'll give you an analogy. This is like relying upon, for a tax question, on the IRS. You don't really beat the IRS on those questions. This is the agency charged with it. It's something that we can kind of take to the bank. Now let's talk about the second criteria in injunctions, and that is the balancing of harms. The harm here, if we were compelled to comply, is the complete rezoning of an entire area of town and the introduction or the requirement to provide infrastructure for that project at significant expense. And again, we don't have to make that up. The auditor has already said there would be a significant expense. How much? We don't know, but they've already determined that there would be. So the relative cost to the community in terms of having to provide additional infrastructure, whether it's sewer or water, public safety, education, other services that may have to be increased in the town, is a real harm to the town. It's something that, as I'm sure Mike can attest to as he's formulating the budget for the Springtown meeting, is not something that we can just snap our fingers and provide for the people of Wrentham. That's a significant ask, and there's a lot of significant hurdles that come along with that. The harms on the other side are a little less clear. I would suggest that the state's primary harm is just that they have to wait a little while longer. Because we're not telling them that the statute is unenforceable. We're just saying you can't enforce it yet. We're not saying that they don't have a right to try and compel us to do something with our zoning. They can try and do that still once they fund it. And again, the obligation for them to fund it is at the onset of a statute. So they can't say that delay is a problem because they're the cause of the delay, not the town. They're the ones that didn't do the work coming in, according to the auditor, that they should have done. So any delay in the implementation of this statute is laid at the feet of EOHLC and whoever else is analyzing these things. So that delay isn't caused by us, nor is it particularly harmful if at the end of the day they fund this statute and pay us our money. Then they have all of the rights under Milton to seek our compliance. How we choose to deal with it at that time, to either pass a bylaw or to continue to have raised concerns about a bylaw, is all future stuff. So no one is trying to tell that story or rush that story. We're just trying to preserve the status quo until the state does what the auditors said they were required to do, but failed to do at the outset. So it's a really kind of long-winded approach to this. I'm sure the select board has some questions. I'm happy to answer them. You know, I'm not going to get too deep into litigation strategy because that's the kind of thing we do in executive session, but I'm happy to answer questions generally about the process.
All right. Thanks, Jay. Appreciate the summary. I am going to open it up to the board for questions and comments. I just want to make sure I clarify something, though. When you say, you know, they can temporarily, the phrase you used, we're asking them to delay, right? Delay, but I just want to clarify that you said that it's really not us determining how long that delay is. If this is in fact an unfunded mandate, which we know it now is, we know the significant expense, they have to provide the funding up front in order to ask us to comply. Is that a fair statement?
That's 100% a fair statement. And I think we can't lose sight of that. It's not our obligation to prove in these situations how much this mandate is unfunded. It's their obligation to do that analysis and fund it. Now, we may, after that, feel that they're not funding it enough, but that's a different dispute and different argument, and we're not at that point. It
Right.
is all on them.
Right. Okay. Secondly, I just want to say, if I'm hearing you correctly, there's a lot of chatter on social media when it comes to this stuff, and I typically don't look at a lot of the chatter on social media, especially some of the local pages we have here. But there's a lot of misinformation out there that I want to try to clarify this evening. One of the things you just clarified, is it a fair statement, Jay, that the Milton case was not necessarily a loss for the reasons that you've already pointed out? I think if it weren't for Milton, we wouldn't have gotten this extension to July, and we probably wouldn't be in as strong of a position as we are today. Again, is that a fair statement?
Yeah, I think it's a fair statement. I think Milton is very much a mixed bag. I think the other element of Milton, and I don't want to stray too far of what we're here to discuss tonight, is the Milton court did not really give any actual relief to the state on this particular issue. What the Milton court said, the Supreme Judicial Court said, is okay, it's mandatory, and okay, you can try and make the town do it, but they didn't say how you do that. Now, I could discuss and it would bore you all to tears on exactly why under municipal law, it would be really hard to compel a town meeting to do something in and around zoning. That's a different argument. So Milton just got them into the front door on this particular thing. And again, I'm not speaking of this in a way that should be implied as being anti or pro housing. I'm speaking just brass tacks. The town has a right to control its own destiny, and the Milton court did not provide any clarity as to how the state may compel a different direction with respect to those choices. So that's really important. But then as it applies to here, and the auditor was clear in their letter, if the Milton court didn't find that it was a mandate, that it was mandatory as opposed to discretionary, we wouldn't be here. We'd be under the clock. We'd have to do something by July. So I don't want to quite call it overreach because hindsight is 2020, but they sought this relief, and now they're in a position where there might not only be situations where communities are excused from compliance, but there may have to be a substantial appropriation by the state government to make sure that towns can have the infrastructure necessary to support the housing that the state government feels is so important. And then frankly, most of the towns feel is important too. They just want to go about it a different way.
Right. Okay, thank you so much. And I really appreciate you running through that for me. I'm going to start with Selectman Anderson and asks if you have any questions or comments for Jay.
Yeah, thank you. Well, Jay, first of all, I just want to say you did a terrific job on summarizing why we're here tonight. And although you probably don't want to go into too many specifics, but going forward, if we were to file to be exempt, and the state decided that they were going to fund us at some point, could we reasonably argue that with the projected 750 units and based on the state's tally of 2.3 people per unit, if that 0.3 was a child, talking about 750 students entering our school system, and our elementary school right now has got about 1,200 students. So that'd be more than half what's already there. So if we had to build a $250 million school, that's something that the state would be expected to cover.
Well, I think the calculation, the formulas for that can be pretty complex because it would have to be compared against what would be allowed, notwithstanding the particular statute. But in essence, the way you're approaching it is correct. That education funding, and there are different arguments as to whether education funding is an area that's within the sights of an infrastructure increase and a mandate. But the way you're approaching this from a mathematical perspective is correct. It wouldn't be any different if we took the school questions out of it and just said, okay, there are formulas for providing different police staffing or fire department staffing, and those things are tied to population increases too, and there's a real cost to those. And then there's sewer and there's water, and there's some interesting arguments in and around that. But a by right use on a road that has water and sewer comes at a significant infrastructure cost to the town in terms of ongoing maintenance as well as lost capacity elsewhere. So the formulas are going to would be very complex, and I would be shocked if it doesn't take them months and months and months to come up with these numbers. Now that the auditor has said, if they even choose to go down that road rather than fight it.
Okay, thank you. And just one more question, if you don't mind. The state auditor, I mean, that's her office opinion.
Well, Jim, I'd call it more than an opinion.
Okay.
So certainly the state's attorney general says the auditor's wrong, and they are entitled to have that opinion. How they challenge that opinion is another question. But it's more than an opinion because they are charged with a statute on making a determination that has legal significance. So, yeah, could it be a subjective result, or could they have the auditor have gone a different way? Perhaps, based upon the analysis and what we've seen out there in other analyses under the unfunded mandate statute. But the fact is that they made a decision, and that decision has legal significance, is our position. I mean, courts can go one of two ways, and a lot of times other state agencies, Department of Environmental Protection, Civil Service Commission, whatever it may be, there are choices they can make, but that doesn't make it any less official. So I think it's much more than an opinion.
All right, terrific. Thank you. And again, kudos. I thought you did a terrific job tonight. Thank you.
Thank you, Jim.
Okay, if no further questions from Selectman Anderson, Selectman Harrington.
Thank you, Mr. Vice Chair. So, yeah, wonderful job, Mike and Jay, for your presentations. Very clear, very right to the point. So my question, I think, was asked and answered by Selectman Anderson. The decision that was made by the state auditor's office is based off state regulations, Mass General Law, CMR, whatever. It wasn't just a determination that they read and interpreted that way. They went based off Mass General Law.
Correct.
Okay. All right. Thank you. I appreciate it. Great presentation. Thank you.
All right.
Thank you, Bill.
Selectwoman Rouse.
Thank you, Mr. Vice Chair. Jay, excellent job going through all the complications and potentials with the situation. Really appreciate the information that you've provided to us. It goes along with, what our board has done this past year to allow our residents to get as much information as it relates to this ever-changing process. So thank you. One thing I'd like you to expand a little bit on is talk a little, if you could tell us how this affects other towns and towns that have made decisions to comply, those that are in similar situations with us. And can the state make decisions? I think a question came up on the chat. Make a decision for Wrentham to fund Wrentham, but not other towns. Would that be an option that the state would do?
So I think it would be difficult for them to fund just the handful of towns that have not yet complied and not fund the other towns. I think there would certainly be pushback. There's a different process and a different approach for a town that chose to comply, notwithstanding the lack of funding. I think that there's a little bit more analysis that's required there. And we haven't, because this is also new, we have been focusing on our municipal clients that haven't complied with MBTA zoning yet. But in thinking this through a little bit, I think zoning is an act of town meeting. If a town that chose to begrudgingly accept the state mandate and pass zoning, chose to, for example, to repeal that zoning, they would be essentially on even footing with where you are right now. They will have chosen not to comply, and then compelling that compliance would be put them in essentially the same boat that you're in. If they choose to continue to comply, how they might petition for funding that was required to have been funded at the beginning is a slightly different approach to things, but I think that there are still remedies and avenues for those communities to do that. I don't think there's been a lot of attention on that yet because most of the attention has been on the few towns that have actually sent letters to the auditor, and then the few other towns that have not complied, either with their current mandate or a mandate that would mature in December of this year. Some of the smaller adjacent communities that still have to comply with things. So a little bit unwritten. I know, Michelle, that's a kind of a dodgy answer a little bit, but
Okay.
there are
Everything's-
remedies out there. There are ways. The spirit of the statute, the letter of it can be difficult to follow sometimes, but the spirit of it is to make sure that no mandate is unfunded. So my guess is that the towns that are unhappy, some towns may be fine with the status quo. That's their choice. But if
Right.
a town that chose to pass zoning wanted to avail themselves of a procedure that would result in funding, assuming the Attorney General doesn't try and fight funding altogether, I think there's a path forward for them. It's a little bit more twisty and turny, I think.
Thank you for that. I appreciate it. In your experience, if a town goes to the exemption route, what do you see as like a potential timeline? And I know that's a big shot in the dark with all the other factors. But do you think that's something that would move quickly, or because we're waiting, for other information, like what do you see that looking like?
And Jay, while you're answering that question, could you also touch on potential legal costs? I know that's a
That's
very
going to be my next one. Yeah.
of
Sure.
our taxpayers.
So you're going to have to travel far and wide to find an attorney that's going to give you a lot of exactitude on the pace of the courts. But this is not a situation where we're taking the kind of legal action that is intensely factual in nature. That could be the second step, what I referred to earlier, if there's a disagreement on the unfunded mandate. The questions that are present here now are legal questions.
Mhm.
There's no debate really on the facts unless the Attorney General chooses to dive deeper into that, but that would be the Attorney General's beef with the auditor. That's not us. We're just relying on the auditor. The questions that would be facing us and the way we would approach this is to make this purely a legal issue. So we don't spend a lot of time and don't spend as much money chasing down facts and getting witnesses and experts who might try and calculate what the schooling costs, as Jim referred to earlier, what that amounts to. That's not what's happening here. What's happening here is there an unfunded mandate? And if so, if the auditor is correct and entitled to the deference in that opinion, what is the relief we get? So we would hope that that would be more motion practice than like an evidentiary or a trial practice. Those kinds of questions are generally resolved through a request for a preliminary injunction at the start of a case. That can sometimes happen very quickly, where you would file an action and along with a motion, it takes obviously some time to prepare those documents. And then the other side gets a chance to respond to it. And within 2 or 3 weeks, you're before the court. Maybe the court decides that day. Maybe the court takes a week, 2 weeks, a month to decide it. But it's the pace of it is not crazy. Now, that doesn't mean we have to go right away. As I mentioned before, we could wait and see. We have until July if we wanted, or we could wait a week and decide. So the pace of it is yours. So, but it's not like something that we would measure in years. If we had a factual trial or a fact-laden trial that we were doing for Wrentham on a particular project where I would have to go through all the mechanics to get facts marshaled for calling witnesses and doing discovery and all that, which takes years. This is a much shorter time horizon there. As to costs, again, difficult to predict until we know more about how the Attorney General may choose to combat any particular action by the town, if the town chose to do that. But, you know, we practice municipal law. Our rates are a little bit more attainable for a community. That doesn't make it comfortable. No one likes spending money that they've allocated for different resources. But we really think that if something is more just driven by motions, a little bit of research, an appearance at an oral argument versus a trial, the costs can be really kept in check, and they'd be much more predictable. Now, there could be curveballs. The Attorney General, as I said, they may bring the auditor into the case. That may slow things down. We may get bogged down in disputes there. There's any number of curveballs that are kind of difficult to predict that may increase the time and increase the cost. But I do think it's a manageable process for any town that chooses to avail themselves of the rights that the auditor says we have.
Excellent. Thank you so much. Appreciate it.
Jay,
That's all from.
thank you, Michelle. Jay, just to touch on that, I know we're not going to sit here and give exact figures, but, we're talking, if I may, we're talking, Ford Focus versus Lamborghini. I mean, is that you know what I mean? Like, you got what we can't have is the townspeople so concerned about the legal cost that we don't do the best thing for the town, right? If we knew that getting an exemption, filing for an exemption might cost us $10,000 or $20,000, my next question is going to be to Mike King, which, Mike, after Jay's done answering the question, I'd like you to answer the question, do we have discretionary funds available? What does that look like? Or, Jay, are we talking about a $300,000 Lamborghini right out of the gate, which I just think it's important for the townspeople to have a little bit more without, we're not asking you to price this thing out. Please.
Right. No, and I think that's a fair question. Look, I've been practicing municipal law, and I've been a municipal official myself for a long time. So I understand it, and I'd be a failure at my job if I was working within a finite municipal budget and blowing through it. We work with our communities to make sure that we give them options to advance in a way that doesn't cripple some other essential municipal service. That said, I think, we're closer to a Focus than a Lamborghini, certainly way closer. For drafting a complaint is not particularly hard. We've got a number of other similarly situated communities, so you probably get a little economy there. They're going through the same discussions that you're going through. One of my partners is in one of those communities tonight. I'll be in another one of those communities Thursday, another one Friday. My partner, Lisa Mead, who does a tremendous amount of work with you, is doing another one a week after that. So there's some economy there. I think what we're talking about, given the size of your overall budget, is a relatively In fact, a significantly fractional expense. Now, I would like to think that the mere filing of a complaint, doing a motion, appearing in court, doing the research could put us in that, $5,000 to $15,000 range to get through that process. That I think is a manageable sum. Again, the other part of this too, it's important to note, is that I don't just take a ball and run with it. Our practice, and we consider ourselves part of the municipal infrastructure here, would be at every single turn to evaluate. And the
Right.
select board, as the entity that controls litigation, can put the brakes on, reach a compromise, do those kinds of things. So, we don't think that we're going to be robbing another essential service in the town, particularly if there's a little bit of discretionary funds. We're going to work with you on that because that's
Understood.
what we do. We know that you're coming up. There's town meetings in a couple months. So there's ways to work in and around that. There's other fiscal resources that every town has through reserve funds, and et cetera, et cetera.
Thank you, Jay. Interim Manager Mike King, can you just give us a quick response on, discretionary funds? Do we have funds available? What are the funds we have available?
Yeah, absolutely. So, if in this case that the town exceeded its legal budget for the fiscal year, there is the reserve fund available, which is appropriated at town meeting. It's $200,000, which could be accessed via the finance committee for a transfer to the legal fund budget to cover any excess expenses. But I just will note that any transfers from the reserve fund require finance committee approval.
Gotcha. And if it was a $5,000 to $15,000 bill, we would be able to pay that from the general levy?
Yeah, I don't see any direct issues with that at this time.
Okay, thank you for that. Jay, another follow-up question. There's been discussions even among this board about potentially joining with other towns. The word class action lawsuit was thrown out. What are your thoughts on that? I know there's pros and cons. Are we better to go it our own? Are we better to join forces? Can you just quickly speak to that?
Yeah, my approach to that would be a hybrid. So there are towns that you will probably end up talking to who are in a similar situation. You'll be comparing notes. Michael will be talking to his counterparts. You'll be talking to your counterparts, and then you obviously will be talking to us, or we'll be talking to their counsel. So you will get all of the cooperation. We recommend that you nominally, in the case, go it alone and be the only plaintiff in the particular action that, if you choose to file an action, that that you may pursue. That doesn't mean that we don't end up kind of joined at the hip a little bit with some other communities. I would expect if for example, next Wednesday, 4 towns filed in their respective counties, there'd probably be some effort for the regional justice for the Superior Court to consolidate those actions. There would probably be that. The reason why we don't recommend that you join with other communities is some of those other communities, and I can tell you it's actually a fact, have additional potential actions against the Commonwealth. For example, one of the communities that I represent who's similarly situated with respect to compliance with the MBTA statute already received a grant just before the original deadline, and that grant has now been withheld. So if they are excused from compliance, for example, they may file an additional action to free up those funds. It's a super important grant for them. Ironically, it is a grant that is necessary to make a multifamily housing development tick. So that kind of thing puts them in a different footing. The other reason why we don't like in either this kind of action or anything similar is because each town is going to make different choices when to stay in, how hard to fight, when to push, when to pull, when to settle. So as counsel, it can be difficult for me to give advice to two communities that start to diverge. You might be in the same place at the beginning, but as your paths start to diverge, it's hard to manage that relationship, either you managing it or me managing it. So we could get the benefit of the synergy of working with other communities while still maintaining your independence in a particular piece of litigation.
Gotcha.
I like that.
Makes a lot of sense.
Mhm.
Jay, what else? We're coming up on an hour here. This has been a very informative piece. I will say this, although we have no public comment tonight, as always, this board strives to be, very, very open and transparent with our voters. I would recommend that anyone that has any follow-up questions, I would ask you to email us at the email address, S as in Sam, B, or for select board office at wrentham.gov. That's the correct address, right, Mike? SB office at wrentham.gov.
That's correct.
Okay, thank you. As always, we're very interested in hearing what our constituents have to say. Jay, before we cut you loose, though, is there anything else that we should be watching out for? Is there anything else that you can share with us? Just trying to make sure we have all the information that's readily available.
No, I mean, this is coming at you just as fast as it's coming at us, and just as fast as it's coming to the auditor, to EOHLC, to the AG. I expect that there'll be daily updates, and we'll do that through the same channels that we always do. We have been at this hard, doing the research, looking at the cases, doing some preliminary drafting, thinking of concepts since we heard the news late last week. I expect that is going to continue. We will report to you anything that we hear, even though there's been certainly some strong words by the Attorney General. I will never shut the door to talking to them. My conversations with the Attorney General's office have been in the spirit of kind of a conciliatory approach to this, where maybe they would accept certain components of this and grant a relief, temporary or otherwise. And I will never shut the door to that. I will give you every option you can, whether it's fight, 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 or negotiate, negotiate, negotiate. So it's going to be an interesting week or so, and I think we're going to try and, if I can, we'll talk more in executive session at some point.
Right, and I agree with you. I think this board, and the board members, feel free to jump in and tell me if I'm wrong. This board remains committed to open dialogue with the state, and we've been asking for that, and we've been saying that the whole time. We want open communication. We just want to have a say in the destiny of our community, and that remains the same tonight. We stayed in interim compliance as another token of good faith, knowing that that doesn't necessarily bind us one way or the other. What we're going to do, if anything, in July. But all we're asking the state for is a seat at the table. We want to have a say in our own destiny. And I do want to take a minute, though, and just give a little bit of kudos to the board and to the town administration team and to the voters. This hasn't been easy for anyone. Everyone's put a lot of time into this. It's sometimes a very divisive topic around town, for sure. There's a lot of hard feelings, strong feelings, one way or the other. I'll tell you what I continue to say. I never thought we should be an early adopter in this. And once again tonight, this board having a steady hand, not being intimidated by threats or any other nonsense, or a tiny little small majority of mouthpieces in our community that don't know the facts. The residents came out in massive numbers showing what they wanted from this select board and validated the hard work of the select board and this executive team over the past year. Nothing's changed, okay? As I've said before, asking us to vote this in without knowing the price tag is ridiculously irresponsible. And anyone who wanted us to do that, I think, should be ashamed of themselves. So nothing's changed. This board remains laser focused on doing what's best for all 11,000 residents. We want to protect our town. We want to protect our destiny, but we also want to work with the state if they want to work with us. Threats don't work here. We're all adults, and we're ready to do whatever we need to do to protect our rights and protect the community. I just want to commend The people, listen, for every 5 or 10 negative emails or horrible Facebook posts that we see, I can't tell you, fellow board members, how many people stop me around town, call me, email me, text me, and say, thank you. Thank you for your hard work. Thank you for not being bullied. Thank you for caring about our town. Because let me tell you something, there's a lot of other communities that rubber stamped this thing and passed it right through, okay? And this board said, I don't think so. So I just want to say congratulations. This is far from over. Collaboration is the key, but we're ready to do whatever we need to do to protect our interests. And I really appreciate you coming on tonight, Jay, and giving us this update. Does anyone have anything else?
Yeah, and my pleasure. You know, the other thing I would say, Chris, and I think I mentioned it when we had talked earlier today, is, you know, I represent a lot of towns and I've done a lot of housing projects in a lot of town. I have worked really hard with the town of Wrentham and the town of Wrentham planner to develop, tweak, make improvements to zoning that you have in your town center, which is where the state wants it, to facilitate the development of good, available, and attainable housing. So I, as someone who advocates for towns almost exclusively, sometimes get a little frustrated when the headline is towns aren't doing anything. Every town, every person could probably do more in some regard. But when someone suggests that the town of Wrentham or any other town I represent or the town I live in even isn't doing anything to provide housing, I look at the efforts of the planning board, of the interest of the town meeting, the favorable votes that you receive for your village zoning. Those are really important initiatives to provide housing for your residents, you know, for your young up and comers, for your teachers and firemen. Those efforts, I think, can't be lost in this. So the next time someone says Wrentham doesn't do anything for housing, I think we can point to those initiatives and feel pretty proud of them.
In the master plan, Jay, don't forget, our
Yeah.
voters, you know, overwhelmingly supported the town's master plan that laid out slow, controlled growth, you know, watching open space, watching infrastructure, and those type of things. So, folks, as we wrap this up, I'm going to open it up to the select board once again. Do we have any last minute questions for Jay or Mike King? And I'll start with Selectwoman Rouse.
No further questions. I think you and Jay summarized everything perfectly. Thank you very much.
Selectman Anderson.
Yeah, no further questions. I think it was a great meeting. Thank you.
Selectman Harrington.
Yeah, thank you, Mr. Vice Chair. You know, I just want to point out that the people that live in Wrentham are the taxpayers. The taxpayers are what funds the government, and for the government to be treating us this way is totally unfair. I think Jay and Mike put a great presentation together. I can't thank Chris and Michelle for the efforts that they've put into this project. Kudos goes to both of you, and I look forward to the good fight.
Thanks, Bill. All of us. Thank you for saying that, but it goes to all of us. And Mike King, do you have anything you want to add before I turn the floor to Selectman Anderson?
Not this time. Thank you, Mr. Vice Chair.
Okay, Ms. Jay, you get to witness what we like to call our formal adjournment. We have a very special select board member, Jim Anderson, who likes to handle the adjournment. So Selectman Anderson, the floor is yours.
Thank you, Mr. Vice Chair. With your permission, I'd like to make a motion to adjourn.
So moved.
All right, is there a second?
Second.
Okay, so motion made by Selectman Anderson, second by Selectwoman Rouse. We'll do a roll call vote. Selectwoman Rouse.
Rouse, yes.
Selectman Anderson.
Yes.
Selectman Harrington.
Harrington, yes.
Chris Gallo, yes. Motion passes 4-0. Thank you, community. Thank you, everyone on the meeting. Thank you, Mike. Thank you, Jay. Have a great night.
Thank you.